I don't care if, as an auditor, you want to give the police bad legal advice. I do, however, care about the people who watch 41,000 people who watch your channel and get bad legal advice. I don't think they deserve it, so I would like to offer up a little insight into where the legal advice goes wrong.
The Supreme Court has said that police officers do not have an obligation to protect anybody, sir. And I'm not doing things that I don't.
The, the police don't have an obligation to protect anybody. The police have an obligation to protect everybody, but they don't have an obligation to protect any single individual. You can see that in Castle Rock v. Gonzalez. This is U.S. Supreme Court, 2005. We're going to go all the way down to the bottom, right before the footnotes. Okay, so stick with me here. In light of today's decision, and that in DeShaney, the benefit that a third party may receive from having someone else arrested for a crime generally does not trigger protections under the Due Process Clause, neither in its procedural nor in its substantive manifestations. That means you can't sue them if they don't arrest somebody. You can't sue them if they fail to protect you under the Due Process Clause of the 14th Amendment. It doesn't mean that there couldn't be some other remedy, and it doesn't mean that a state can't say, well, yeah, you can sue them under state law if they fail to protect you. It just means you can't do it under the Due Process Clause of the 14th Amendment. This result reflects our continuing reluctance to treat the 14th Amendment as a font of tort law, but it doesn't mean the states are powerless to provide victims with personally enforceable remedies. Although the framers of the 14th Amendment and the Civil Rights Act of 1871 did not create a system by which police departments are generally held financially accountable for crimes that better policing may have prevented, the people of Colorado are free to craft such a system under state law. Also, nothing in here said that the police couldn't protect anyone. Now, when can police protect people? Well, they could protect people by moving them out of areas that are experiencing natural disasters. For example, this is California Penal Code 409.5. Whenever a menace to public health or safety is created by a calamity, blah, 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 they can close the area by means of rope markers or guards, et cetera, et cetera. It says that the police can kick you out. Now, this may also be what our good friend High Desert was thinking of when he said the Supreme Court ruled that, because this is something that J.C. Playford likes to mention. He likes to mention 409.5. When he's getting told to get out of the road, he likes to say, you're not responsible for me or whatever. Look at 409.5. And this is the part that he's thinking about. This is subsection D. Nothing in this section shall prevent a duly authorized representative of any news service, newspaper, or radio or television station or network from entering the area closed pursuant to this section. He forgets that this section is dealing with natural disasters, not just allowing people to walk along the side of a highway. Had High Desert Community Watch wished to sound smart and educated, he would have looked at Prisoners Union v. Department of Corrections. This is a California decision in California State Court of Appeals. And what they held was that the parking lot, the public parking lot of a prison, was a public forum as far as the California Constitution is concerned. That's Article 1, Section 2, I believe, of the California Constitution. We could look it up. We're going to go up. Come on, baby. Go up. Go up. California Constitution. Article 1. Section 2. Every person may speak freely, write, and publish his or her sentiments on all subjects, being responsible for the abuse of this right. A law may not restrain or abridge the liberty of speech or press. They call this the Liberty of Speech Clause in California. California has a great First Amendment protection. The liberty of speech clause allows you to film in the parking lot of a prison, whereas Adderley would have, under the U.S. Constitution, Adderley v. Florida would have said that the state can stop you from doing that. Now, considering they're filming in front of a detention center, prisoners' union may apply, but they're on a sidewalk, it looks like, so just normal First Amendment analysis would have protected them. Now we're going to continue on a little bit.
I don't know if you actually know the ruling on which case.
So are you really that argumentative and dumb?
No, I'm just.
So then why won't you let somebody else finish the whole sentence?
I can say the Supreme Court ruled that we can charge people for breathing air.
Okay, now you're being an idiot. I'm sorry, but you're being an idiot.
If I give you an actual
Pots shouldn't call kettles black.
Supreme Court case,
Yeah, you're being dumb now, sir.
then you can look it up, right?
You know 148.G, California Penal Code?
148.G.
Yes, sir. Section
148 per NG.
148 subsection G, sir.
Subsection
148 subsection G. He says it himself. It's subsection G.
Yes.
I can't quote off the top of my head.
Well, that is the law on public photography, sir.
Okay.
And
It's not the law on public photography. It is the law on, here we go. All right, so 148. This is 148, subsection A. This is the obstruction of justice section. B refers to subdivision A. C refers to subdivision A. D, except as provided in subsection C, and notwithstanding subsection A. Notice the pattern here? Do you notice the pattern here? Subdivision A. This section, the whole section, should not apply to any officer. And then look, G applies to subdivision A. That's amazing, isn't it? Now, what that means is that everything in here all works together. It all applies to resisting arrest. That's why it's all in 148. Notice that this is 148.1. It's not 148 subsection 1. It's 148.1. It is a completely different section than 148. 148.1 deals with other different things. There's another way they could have done it. You can see that in the 146 section. This is 146D, not 146 subsection D. This is 146D. This is a completely separate section from 146E. Now 146E has subsection A, B, and C. All those three apply together. So it's going to be a violation of A. For the purposes of this whole section, it's defining something. 146F. Do you get the idea? 148 subsection G applies to 148A subsection A. It's all connected. It's all obstruction of justice. So what 148 subsection G says is that filming the police does not, in and of itself, give them probable cause or reasonable suspicion of obstruction of justice. Now there's another section that deals with this a little bit. Uses very similar language. And it's 69, my favorite subsection. This is the filming of executive officers, and they say that, you know, taking photographs or video or audio while the officers in a public place doesn't violate subsection A. Yeah, so that's really all I wanted to say for this. Bad statements of law that are misleading or wrong. The officer was correct. You know, you could throw out whatever you want. The Supreme Court says that bananas are blue, but that doesn't make bananas blue. So having a citation would keep me from not knowing what you're referring to, and it would keep your supporters from being misinformed about the state of the law. And just remember, for everybody out there, that prisoners' union is decided on the California Constitution. It's not decided on the U.S. Constitution. So if you are not in California, it would not apply to you. So bear that in mind. Thanks, and have a great day.